Hi, it's Dr. John Raymond Baker. I'm a chiropractic doctor in Longview, Texas, and today I want to talk about two things that have to do with workers' compensation here in Texas. One is the definition of MMI, maximum medical improvement, which means that there's actually two MMIs. There's statutory MMI, and that means that 104 weeks have passed since your benefits began. That's 2 years, and that's an MMI date. And then there's a medical or clinical MMI, and their definition is medically it's the point in time that an injury or illness has improved as much as it's going to improve. And in Texas, your MMI date basically is the earlier of those two things. If 104 weeks passes first, then that's going to be your MMI date. Or if you get improve as much as you're going to improve, then that's your MMI date. It's the earlier of the two. And with the notion of improved as much as you're going to improve, if you hurt your neck, your shoulder, your low back, and your neck and shoulder have improved as much as they're going to improve, but for some reason the carrier has held up your ESI injections, which they say may help, and has denied your surgery, which is waiting out there if the ESIs don't help, then you're not an MMI, because all your compensable injuries, compensable meaning flowing from or caused by the accident, your compensable injuries are not taken care of, that there's hope that one will improve more after surgery. So you're not going to be an MMI. At least that's my interpretation as a reasonable person. I think it's a pretty straightforward interpretation. Though I'm not a lawyer and I'm not playing one on TV, so I'll leave that to the lawyers to explain. But the other thing I wanted to talk about was that we had a Supreme Court of Texas decision, Texas Mutual Insurance versus Rudiger, and basically what came about from that was that the Supreme Court said that bad faith lawsuits are inconsistent with the Texas workers' comp system. Now, what's a bad faith lawsuit? Again, I'm not a lawyer, but in Texas, insurers have a duty of good faith and fair dealing toward the insured, meaning that they should treat you just like they do every other insured person, not target you to hold your claim up or lie to you, or, in other words, they have the duty of good faith and fair dealing. If they breach that or they don't fulfill that duty, then in the past, we've had what's called bad faith lawsuits. Well, this new ruling from the Supreme Court is that basically there are no more bad faith lawsuits in the work comp system. Now, they did find, as I understand, that you still have a cause of action if you've actually had it misrepresented to you. And I'm sure that's up to special definitions and interpretations. But anyway, basically what I'm saying is that it seems like bad faith lawsuits in the work comp system are dead now pursuant to this decision. So we've covered MMI, we've covered the new bad faith ruling, and I guess that's going to be it for today. Hope you enjoyed my little video. I hope it was entertaining, if not informative. Have a good day. Bye-bye.